This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we speak about what happens to a litigant when they file suit late. They lose, and why a private limitation of action provision will defeat a suit against an insurer if not filed timely. In a case entitled Vishnudut Ramyead versus State Farm General Insurance Company, the California Court of Appeals on April 29, 2025, resolved a purported class action suit because it was filed late. After their personal property suffered water damage, plaintiffs and appellants Vishnudut and Teika Ramyead, the plaintiffs, submitted a claim to their property insurer, State Farm General Insurance Company. State Farm paid the plaintiffs a total of $750.75. Dissatisfied with State Farm's handling of their claim, the plaintiffs filed a class action lawsuit against State Farm, bringing causes of action for alleged violation of the unfair competition law and declaratory relief. The trial court granted State Farm's motion for summary judgment because of the late filing of the complaint. Plaintiffs had taken out a homeowner's policy with State Farm, which was effective for 1 year from February 17, 2018. The policy established that in accordance with state law, quote, no action shall be brought, close quote, against State Farm, quote, unless there has been compliance with the policy provisions, and the action must be started within 1 year after the date of loss or damage, close quote. On May 8, 2018, a leaking water supply line damaged plaintiff's property, including a sofa and ottoman and an adjacent bedroom. On May 10, 2018, plaintiff's attorneys filed a claim with State Farm. They reported that the value of the sofa and ottoman was $2,500 and $1,000 respectively, although both pieces were about 20 years old. On February 19, 2020, plaintiffs filed a class action against State Farm. Their operative first amended complaint set forth 2 causes of action: 1, violation of the unfair competition law, and 2, declaratory relief. The fact alleged that State Farm violated California law by adding sales tax to the retail price of personal property before finding and subtracting the property's depreciated value. Plaintiffs contended that this practice effectively depreciated sales tax, a non-depreciable item under Section 2051 of the California Insurance Code and related regulations. As a result, State Farm wrongfully was alleged to have withheld money that it is owed to the plaintiffs and those other insured similarly situated. Among other things, the fact sought disgorgement of all sums unjustly obtained by State Farm and restitution to plaintiffs and other policy holders. State Farm's summary judgment motion was filed in December of 2022, arguing that 1, plaintiff's claims were untimely because they were brought after the 1-year limitation period, and 2, as a matter of law, Section 2051 of the Insurance Code does not prohibit depreciation of sales tax. The trial court granted State Farm's motion for summary judgment. The trial court ruled that plaintiffs' claims are indisputably untimely because plaintiffs' claims for unfair competition and declaratory relief seek to recover amounts they contend State Farm should have included in their payment under the policy, and California law, their claims are on the policy for purposes of the 1-year limitation contained in the policy. And moreover, the trial court found that Section 2051 and related regulations do not bar an insurer from depreciating sales tax when calculated actual cash value. The expiration of the applicable private limitation of action provision is a complete defense. If the movement presents evidence establishing the defense and plaintiff did not effectively dispute any of the relevant facts, summary judgment was properly granted. The parties disagreed about which statute of limitation applies to plaintiff's lawsuit, and plaintiffs contend that it falls under the 4-year period of limitation governing unfair competition law, or the 4-year statute governing breach of contract. The Court of Appeals held that Section 2071 is concerned with causes of action that in some manner seek a financial recovery attributable to a claim loss that was covered under a policy. In the fact, plaintiffs request not just declaratory and injunctive release, but also return of the money that, per the plaintiff, State Farm unlawfully withheld from the amount owed on their claim. 3 dates are used to ascertain whether a plaintiff files suit within Section 2071's limitation period. 1. The limitation period starts running on the date that the insured discovers a loss to covered property. In this case, plaintiffs discovered the damage to their furniture on May 8, 2018. 2. The clock stops running on the date that the insured reports the claim. Plaintiffs submitted a claim to State Farm on May 10, 2018. And 3. The limitation period resumes running on the date that the insurer closes its investigation into the insured's claim. Plaintiff's lawsuit, according to the Court of Appeal, was untimely. The limitations period began to run on May 8, 2018. Plaintiffs stopped the clock 2 days later when they filed their claim on May 10. At this point, 2 days of their 1-year limitation period had already elapsed. Thus, from the date State Farm closed its investigation, plaintiff had 1 year less 2 days to file suit. Assuming that State Farm closed the investigation on November 14, 2018, plaintiffs would have had until November 12, 2019 to sue. If State Farm did not close the investigation until February 19, 2019, then plaintiffs had until February 17, 2020. But they did not file this lawsuit until February 19, 2020, 2 days after the last date on which the statute of limitations could have expired, because State Farm successfully established that the applicable statute of limitations bars plaintiff's lawsuit, and plaintiff did not effectively dispute any of the relevant facts. The Court of Appeals affirmed summary judgment in State Farm's favor. And State Farm was not only a winner, but was also entitled to its costs on appeal. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5 or 6 a week, and gain access to the more than 5,050 blog postings. You can also subscribe to these videos on YouTube and rumble.com, and if you do, I'd appreciate it if you click on the like button on YouTube or the thumbs up button on rumble.com. And I also ask that you please tell your friends and colleagues about the blog and the videos so that they too can subscribe. And if you're interested in further detail about insurance, insurance law, and insurance fraud, please consider subscribing to my Substack publications for a very small fee. Thank you for your attention.